on this morning's Ag Issues program. A pleasure, as always, to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine. Good to be with you.
Well, this time of year, of course, we look back at the top 10 developments in agricultural law and taxation. And, well, let's just get started because it's a list of topics that we have discussed throughout 2023. And let's start first, United States versus Osage Wind LLC. But this has to do with entire commercial wind development order removed.
Yeah, Greg. In 2023, this is a big development, probably the biggest with respect to wind energy or other so-called renewable energy sources. But in 2023, it just in that year alone, including the court's opinion in this case I'm going to talk about, there were 51 restrictions or rejections of wind energy products across the country and 68 rejections of solar energy products. So they're running into all types of legal issues. And this case in Oklahoma against Osage Wind involved a federal court at the end of the litigation that's been going on since 2011, ordering the wind energy firm to remove the entire commercial wind energy development. And that involved 84 towers spread across 8,400 acres of the tallgrass prairie in Oklahoma. This had been going on, the litigation in this had been going on since 2011. It was the longest running legal battle concerning wind energy in U.S. history. And before this opinion, we had a 2017 opinion in this case by the 10th Circuit Court of Appeals saying that the wind energy company needed to get a mining lease from the Osage Nation down there from the federal government because they were mining minerals. And without that, they couldn't continue their development. Well, the company did not do that. And so the federal court on the remand from the 10th Circuit said, all right, you didn't get the lease. You've got to take everything out. And so now we're down to the damage phase of this. How much are they going to have to pay the Osage Nation for damages to the property? Plus, it's estimated that the removal is going to cost the company about $300 million.
Is this based, or one of the examples, I guess maybe is the better put it, of what we're starting to see with more increasing opposition in rural areas to wind energy production?
Yeah, I think so. And I think that's a fair statement to make. It's something rural communities are waking up to that I started talking about 25 years ago, because my concern was you're going to have basically the rural landscape being used to export energy to urban areas, and they don't really care about what's going to happen in the rural communities, and they don't have respect for property rights. Well, that's a general statement. That's not true in every instance, but I do think that we have seen over the last several years an uptick in landowner opposition to these, and the courts are saying, and particularly this court in particular pointed out that the company's continued refusal to get a lease constituted interference with the sovereignty of the Osage Nation and was sufficient to constitute irreparable injury. So the courts are putting their foot down, telling these companies, look, you need to pay attention to what the requirements are, and you need to pay attention to these court orders. And when the U.S. Court of Appeals for the 10th Circuit told you needed to go get a lease, you need to go get a lease. You need to get a mining lease because you're mining minerals through your development process. So this is probably a development that's going to continue, and we'll see more and more opposition to this, particularly on the solar side of things. That seems to be what's next, and that has a very wide impact on agricultural land. And it's really questionable, at least, Greg, in my mind, when we take, for example, highly productive, let's say, Iowa farmland out of production and put solar panels on it. If you're going to do that, I think it should be tailored to the least productive land possible, not the highest productive land. But that's an issue that agriculture is going to have to continue to deal with.
And next up, as far as the top 10 developments, this has to do with reporting foreign income.
Yeah, this is another development in agriculture. We've seen more and more farmers, including Kansas operations, that have started branches of their farming operations in foreign countries. For Kansans, it's been particularly in Mexico as well as in Brazil. When I'm up in the northern plains, it's Canada, where they'll do operations across the border in Canada, and sometimes unknowingly. To many people, there is a federal requirement that says if you have a foreign bank account, you have to report that bank account to a branch of the Treasury by a certain form. It's known as the FBAR form, and it has to be reported to the Financial Crimes Network. And if you don't file that form reporting your foreign bank accounts, the penalties can be very, very severe. And we had a case go all the way to the U.S. Supreme Court in 2023 on the amount of penalties. And what we had here was an innocent person. He was a dual citizen of Romania and the United States. He immigrated to the U.S. in 1982, became a citizen of the U.S., and lived here until 1990, and then moved back to Romania. Well, he was a wealthy person. He had various Romanian investments amounting to over $70 million. And he ended up having 272 foreign accounts. They were foreign to the U.S. with high balances exceeding $10,000. So there's your requirement there. If your foreign account has a balance in it at any time during the year of $10,000 or more, it doesn't matter what the balance is at the end of the year. You have to report that. You have to file that, what's known as that FBAR form. Well, he wasn't aware of that filing requirement for those non-U.S. accounts, and he's got 272 of them, and the IRS wants to impose a penalty per account. That gets the penalty that the IRS wants for not filing their form up to almost $3 million. And his argument was, wait a minute, this is not a willful violation. If this were a willful violation, that fine would have been multiple times $3 million. So this is an innocent, non-willful violation. But his argument was, look, I file one form to report all of my accounts each year. That's the requirement on that one form. So my penalty should be 5 times $10,000, which is the penalty for a non-willful violation for failure to file the form. I didn't do this for 5 years, and so the fine should be on a per account basis, or excuse me, per form basis, not a per account basis. And he won that argument at the U.S. Supreme Court barely, 5-4. So his penalty, instead of being just shy of $3 million, was $50,000. But the point is, if we've got farming operations in other parts of the world and we open a bank account and we get a balance at any point in time over $10,000, you've got to file that form. If you know about the requirement, then you could end up in prison with this. So this is, we're seeing more and more of these operations in different parts of the world by farmers in the United States. They have to be aware of this requirement. And this is under the Bank Secrecy Act, which actually goes back to 1970. So this is nothing new. It's just ramped up in its application to agriculture in recent years.
All right, before we go to the break, we've got our next one coming up, and this is with regards to new corporate reporting requirements.
Yeah, Greg, this is important for all farming and ranching operations, except very few. This is under the Corporate Transparency Act, was enacted back on January 1 of 2021 as a result of a veto override by President Trump. President Trump did not want this, but Congress pushed it through. And what this is going to require is businesses to report their beneficial ownership information. And people can go to my blog. I don't have time to dig through all of this and read the requirements on this. But basically, this is what it is. If you have a business that is registered with the state, has to file with the Secretary of State's office, has to register with the state. So that would not include the sole proprietorship, for example. But any business that has to register with the state, then you have a federal reporting requirement starting this year. And if you were in existence prior to 2024, you have until the end of this year to file this beneficial ownership information form again with the Financial Crimes Network, a branch of the Treasury. So it's basically IRS, and tell them who has 25% ownership in the business. So the government wants more detail on who these owners are. And this is to deal with people that set up shell companies and are not paying tax, and it's just to deal with tax evasion. That's the purported purpose of this. Now, if you were in existence, as I said, before 2024, you got to file by the end of the year, and that'd be December 31 of this year. If you are new this year, you've got 90 days from the start of the time you file with the government, and then after this year, you've got 30 days from the time you file with the state government. And so people can look at my article on this one. This is going to apply to many, many, many farming and ranching operations throughout Kansas and throughout the United States. It's probably you want to have your attorney file this. CPAs will not want to do this for you because they've been told that their malpractice carriers will not cover them for this. And so you need to have an attorney file the required information for you. If you want to learn more about this, take a look at my blog article or go to the FinCEN website and familiarize yourself with what that form looks like. It's all posted there on FinCEN, FINCEN.
Roger McEowen, professor of agricultural law and taxation, excuse me, at the Washburn University School of Law, is joining us. And Roger, we're going through the top 10 developments in agricultural law and taxation in 2023. This has to do with the IRS, or their Criminal Investigation Division, but this was rather big. One of the largest tax fraud schemes in the history of the United States. This has to do in association with a $1 billion biofuel tax fraud conspiracy.
Yeah, that's right. It made number 7 on my list. I think it's the first time since I've been doing this, over 25 years of compiling a list, I've had an IRS Criminal Investigation Division case reach the list, because we don't. These are ag developments, and that's usually not in the domain of ag, but this one sure is. And the IRS CID views this not only as their number 1 case in 2023, but they're viewing it as one of the biggest fraud cases ever in the history of the United States, and it involves the Renewable Fuel Standards RIN program and the criminal activity associated with that. That has been beset with fraud almost from the get-go, but they really busted up a big crime ring concerning the RFS and got a lot of prison sentences for individuals. This was 5 people involved here in a $1 billion biofuel tax conspiracy that they ran from 2010 to 2018, involving money laundering, mail fraud, and the fraudulent claiming of more than $1 billion in refundable renewable fuel tax credits. And of course, with the RFS, this all started back in 2005, and then it was expanded in 2007. But the RFS, under that, the government provides lucrative subsidies and tax credits to companies that convert crops such as soybeans and corn and other products into so-called renewable fuels. The most common of those is corn-based ethanol, at least in the United States. Included in the RFS are biofuel production incentives known as RINs, or renewable identification numbers. And under the EPA rules, there's a 38-digit number that's designed to track each gallon of ethanol or biodiesel from the producer to the point of sale. And those RINs stay with the fuel until it's pumped by a consumer at the gas station. But the biodiesel RINs can be sold separately as credits that can be traded. And that allows oil refiners who fail to blend the government-mandated amount of biodiesel to buy RINs to make up the difference without paying a fine. But when you separate the two, it also allows the possibility that a RIN price could be negotiated by a biofuel company with an oil refiner, with the company using a fake 38-digit number. So if you get both parties of the transaction that are in on the fraud, the scam can really skyrocket. So what happens in that situation is that the RIN buyer then claims to have shipped the biofuel to be refined. No fuel is actually bought or sold, and both the buyer and the seller, again, if they're in on the scam, they can accomplish that. And that's what happened in this situation, and we ended up with huge amounts of tax dollars being scammed away from taxpayers, lots of fines, hundreds of $1 million of fines against these people, and long prison sentences. So it was a huge, huge fraud, and unfortunately, agriculture was involved in it.
As we move on to our next of the top 10 developments in agricultural law and taxation in 2023, this has to do with self-employment tax and limited partners?
Yeah, Greg, this was a full tax court opinion that came down late in 2023, but it's an issue that I've been watching for some time, and there's a bigger case behind it if it doesn't settle, and I'll explain that in just a second. But what is at issue here is the ability to take, say, a farming operation, a ranching operation, and structure it for tax purposes as well as government farm program payment planning purposes as a limited partnership or an LLC taxed as a limited partnership. And if it's an LLC, we can create a manager-managed LLC where we have a designated manager and the others are non-managers, in essence, limited partners. So in that case, what you can do is the distributions that are paid to the limited partners, not guaranteed payments, but other distributions coming out of the LLC, the partnership, are not subject to self-employment tax. And there are special rules. There's a Treasury regulation that we rely on to do this. And that regulation was developed by the Treasury in 1997. It was frozen by the Congress in 1998. And then it's never been finalized because Congress told IRS they couldn't finalize it. But that's been 25 years ago. And IRS has to have a position on this. And so they've been enforcing their regulation. And one of the things it says in that regulation is that you can't separate these interests out if you're a professional services company. Well, what we had in 23 was an investment firm out east on the East Coast that tried to do this, tried to use that rule that we use in agriculture in the non-agricultural setting for this investment firm. And they didn't pay self-employment tax on distributions to their limited partners. And they lost big time in the tax court, in a full tax court opinion. Now, the case that's behind that involves the owner of the New York Mets, who operates a hedge fund in New York City. And he paid $350 million in distributions to limited partners, didn't pay self-employment tax on it. And I think what IRS is saying here is you can't do that in the context of a professional services firm. Now, if the opinion goes the way we think it will go, if he doesn't settle and we get an opinion, we're still going to be able to do that type of planning for our farm and ranch clients and maximize government payments at the same time. But it's a case that I'm watching in case we see something weird come out of the tax court that we're not expecting with respect to these final regulations. But clearly the court is agreeing with the IRS that they're going to follow what the IRS regulations are on this. And that's good news for agriculture. It's bad news for the hedge fund operators and investors that are in professional service businesses.
All right. Well, we've made it through number 6 as far as the top 10 developments in agricultural law and taxation in 2023. And Roger, if they want to read any of what we've talked about today, and then, of course, obviously, as we head a little further down the road here, as you mentioned earlier, they can go to your blog.
That's right. They can go to my blog. Also, they can catch it on Ag Manager website over at K-State.
All right, sounds good. Roger, as always, very much appreciate it and look forward to the top 5. We'll discuss that here in a couple of weeks.
Thanks, Greg. Appreciate it.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he has been our guest on the Ag Issues program here on 580 WIBW.